webinar brought to you by TOMO Drug Testing. TOMO Drug Testing is driven by a passion for customer service and outstanding client relationships, with creating raving fans. Testing is not an add-on service, afterthought, or necessary evil. It's all we do. Our clients won't experience frustrations from poor turn time, disappointment in the professionalism, qualifications, or availability of collection providers, or concerns regarding the logistics of compliance of testing processes. We are the right provider for all companies, but when business or entity values expertise and customized drug testing solutions delivered by friendly and professional staff, they are pleased to know they can a raving fan experience at TOMO Drug Testing. This is Department of Transportation, drug-free workplace programs, random student drug testing, judicial and court order testing, compliance and program administration, mobile and on-site testing availability, 24/7 nationwide post-accident network, supervised response and training. Today is entitled New Post-Accident Regulations in the Workplace. What do you need to know? Presented by Nina French. Nina is a partner and principal consultant at CCG and has over 24 years of experience in this industry. She specializes in product design, business development. Nina works with employers to design forward-thinking screening programs and screening companies to align their products and services to their key markets. She consults on all aspects of drug testing and employee screening operations, including SA and compliance monitoring. It will now be a pleasure to hear from Nina French.
Good afternoon, everybody. Happy Wednesday. We're happy today to be presenting on behalf of TOMO. We've worked for a long time. And today's topic is going to be specifically on regulations, the new regulations. And before we start, the new OSHA regulations are a broad regulation. It's about 295 pages of information related to record keeping. Today's topic is going to be the OSHA regulations specifically as they relate to post-accident and post-incident drug testing. I'm not going to cover the broader topic of all of the OSHA regulations and the reporting guidelines and what it means. So, when we get to the Q&A period, that is, just want to be clear that that's what we're covering for today. It has impact, and there's a lot of confusion as to drug testing. As soon as these regulations came out, CG, we heard a lot of concern about the employer's ability to do drug testing. And there was a lot of confusion about whether or not testing would be allowed based on how the regulations were being read. So today what we're going to do is we're going to go over the key points of the new OSHA regulations. We're going to go over what really the rationale was, right? So this up, what was the issue they were trying to solve? What the impact of these new regulations are for most of you who are employers. What's the impact going to be on the policies that you have? We're going to talk about impairment because that's important in was published and the new regulations. And then we're going to talk about some of the exceptions and what to expect next. And towards the end, what TOMO and the team has asked us to do is to provide you really with a tool that is an action item list so that when you walk away from today's training, you can literally print out the list and have a to-do list that works for your organization as it relates to the OSHA regulations. So key points in the new OSHA regulations already, and we're going to explain why as we go through today's presentation. But August 10th, these OSHA regulations were to begin enforcement. And there's two dates that are in the regulations that are important. Well, now there's three. The first was August 10th, which was when OSHA was originally slated to begin to enforce the regulations. The second important date was January 1st, 2017. So the regulations as a whole, regulations as a whole are the conversion of OSHA-regulated employers to an electronic record-keeping system for accidents and incidents in the workplace. About 295 pages. There are 10 pages in the preamble that affect drug testing. So the specifically related to when you've got to do the record keeping, how many employees you have, and how the record keeping has to convert to electronic, that's a January 1 initiative. The drug testing issue was going to come into play earlier because simply OSHA could start to enforce as of August 10th. But you're going to see as we move through the slide deck that there's been a change, and it's now delayed to November 1, 2016, and we're going to talk about why as we go through and start to understand what the OSHA regulations are. But the key point is that it is that now there has to be a reasonable procedure for employees to report work-related injuries and illnesses. That employers cannot retaliate or discriminate against an employee who reports an injury or an illness. And really the foundation of what we're going to be talking about today. The rationale that OSHA used, and maybe rationale is not the best word, but, why do this? Where did this come from? It was determined through collection of their data and through the information that they received from employees, that some of the practices that were being used in workplaces discouraged or punished employees from reporting work-related injuries and illnesses. What to do with the new regulation is to ensure that any adverse action that's taken is a violation of the OSH Act, and the violation can be and we'll talk a little bit more about what that penalty can look like. And again, remember now this has been a little bit delayed, so they cannot issue penalties or citations until November of 2016. An employee or a complaint under this new act to be done within 30 days of the adverse action. Under the new OSHA citation, under the new OSHA regulation, OSHA citation within 6 months of this action. And this is the piece that started getting people really confused. The employer could be required to pay a penalty, but also could be ordered to make the employee whole. So that means reinstating them with full back pay for anyone who was terminated. And this is where it started to get tricky and started to get people confused about could they do drug testing, because it could happen as a result of a positive drug test. So we're going to look at how that happens. Specifically about OSHA and OSHA requirements and the definitions. So if you're an OSHA-covered employee, you should know what constitutes an accident or an injury in the workplace, and make sure you do understand that. But what the regulation is starting to talk about is that they will now be determining motivated the employer to issue the discipline. So if then that a drug test was taken as a result of an enforcement of a safety rule, that's okay. If it was of the employee injury and procedures were properly followed and the policy is correct with these new requirements, that's okay. We're going to talk about the exceptions, right? So if it's in compliance with a drug-free workplace policy, that's okay. But if it comes in and deems it retaliatory, it's not. And that's where those fines and citations can start to come into place. And the Department of Labor, in June of 2016, announced an interim final rule on the Federal Civil Penalties Inflation Adjustment Act. And so basically what that means is in the Fed Register in July, they said that there are going to be new increases to what the civil penalties can be. So think about this, right? So you can, a serious violation can be $7,000 to $12,471. A repeated violation can be $70,000 to $124,000 and change. I'm rounding here. A willful violation can be that amount of money. A failure to abate violation can be that $7,000 to $12,000 lower figure, right? So those are significant. There's also, when you note on that previous slide, that they're saying you all then would be liable in some cases to reinstate that employee and make them whole. So if the employee takes 30 days to file a complaint with OSHA, and OSHA takes 6 months to read that citation, on top of that, you can start to imagine what the costs of violations can be to you as an employer. And so it's important to realize that these are significant, but quite as scary as they're being made to believe, or people are starting to believe. So the other piece of this is, and again, we're not lawyers at CCG, we are consultants in the drug and alcohol and substance abuse testing industry. So this is not meant to be legal information, but it is information that you can glean from the regulations themselves. But what they're saying now is that the injured employee may become a protected class. So it allows and affords the employees more of a hammer, right, in terms, more hammer. Employees now have a way to litigate the retaliation cases. OSHA can then do citations, pay the back pay, and reinstate the employee. And so the and the significance of determining retaliation is important because you can see that if your policies and your procedures universally are going on, then you can see how this might not be a single employee issue. Your policies and procedures in your workplace can cause a significant group to be able to make a claim and under the new OSHA regulations. What are unreasonable procedures? So under the new regulation, a procedure is not reasonable if it deters or discourages a reasonable employee from accurately reporting a workplace injury or illness. There are many examples, and we're going to get through some of those through today. But one example would be that an injured or an ill employee is required to report a condition within an hour, right? That would be deemed, and we're still pending on some stuff, but that would be deemed to be unreasonable. If you had something in your workplace that required somebody submit to report an injury prior to seeking medical attention in a critical situation, that would be considered unreasonable. I don't think anybody does that, but that would be considered unreasonable. And so you really have to make sure that the requirements of your employees and your supervisors need to be aware of it, by the way, are not able to be deemed unreasonable in the eyes of OSHA, which is, if you're looking at that statement, you know, it's a lot of gray, right? There's a lot of gray in that statement. If it would deter or discourage a reasonable employee from accurately reporting a workplace injury or accident. That's one of those statements that makes me always think of Law and Order episodes where people say eyewitness testimony is never deemed accurate or really deemed accurate because everybody sees it differently. I don't know. I don't know if JT thinks that Liz is reasonable or not. I don't know if somebody would deem me reasonable. So there's still a lot of gray. And so what's important here is to use best practice, and that's what TOMO's asked us to do. Their focus, when we spend the training, their focus is on compliance, best practice, specifically for this industry. And so what we want to do today is help you build the best practice to eliminate as much of that gray area as you can as interpreting these regulations. Some other examples, because it took me a while, and it took me to read the regulations because right? But it took me a while to really get in my head what is unreasonable. And these examples that were specifically listed in the preamble helped it make sense to me. So the 1 hour made sense. This makes sense. Following drug tests following a bee sting, right? So if I am allergic to bee stings and I'm on the work site and I receive a bee sting and I go into require an EpiPen, I need to be in an ambulance. Post-accident drug test policy that just states requiring medical attention has to go and get a drug test would be deemed too broad. The beating and the post-accident, they don't mesh. If it was a repetitive motion injury, think carpal tunnels and those types of injuries. If it was a back strain or cumulative trauma, those things are not evidence that would meet the criteria of what is suspicion or reasonable probability of drug use. And we're going to talk about that in the next slide. So a blanket post-injury testing prohibition is what they don't want. Citing a lot so that you can, if you want to, go online and you can look at the regulations, and these sections are specifically cited so that you can go in, search, and see where this is the regulation. But it 1804.35 separately provides that an employee may not discriminate against the employee who reports the injury or illness, that it specifically mentioned drug testing. Right? This not about drug testing. It sort of flowed into drug testing because what they wanted to make sure of was you had a reporting procedure for your accidents using their new electronic format that didn't discriminate and didn't prohibit employee or didn't or make difficult or reporting of an accident or injury in the workplace. Drug testing, but they clear in preamble, and that's those 10 pages of the rule that we talked about, that a blanket post-injury drug test by OSHA to deter proper reporting, and thus it could be subject to that OSHA citation we talked about. Now, far in the opposite direction. So when trying to avoid blanket policies, you can go far the other way. For example, people were involved in an accident. One was injured, one was not, a forklift accident, right? Tested the injured one, but then you didn't test the uninjured one. They were both part of the accident. So that would be deemed inconsistent. And that could mean that you're discriminating against the one and not the other. And would fall under that idea of retaliation. Driver caused the accident, hurt a coworker, but was injured himself. You would want to test both of those people. Most of you who are doing drug testing are familiar with the term reasonable suspicion. Very careful in today's presentation and in our consulting regarding the new OSHA regulations to change the wording and to say reasonable possibility, because we don't want it to get confusing with most of you who also have to comply with one of the DOT modalities. So reasonable suspicion drug testing under the DOT is this. Reasonable possibility. So once in drug testing, that wasn't the rationale. But they want to make sure that it's non-retaliatory. As an employer, we're going to talk about, again, action steps and what you can do, but you allow testing if an employer is conducting the test to comply with the regulations that are required for a state or a federal law. And we're going to talk specifically about some of those that are going to apply to many of you on this call. You do post-accident drug testing if there's reasonable possibility, right? So if you are an employer who's got these OSHA regulations, was there reasonable possibility? So it's like, again, that sort of gray shade on the reasonable suspicion. But right, it's possibly have had a role in this accident. And the answer is yes. It could have been a contributing factor in the injury or illness. Then it's okay to do a post-accident drug test. They have not provided, and apologies, but they have not provided any useful information and guidance on specifically evaluate that. So many of you know, again, covered under DOT or in the past with OSHA, what sort of sample policies would look like or what they want to include in there. They haven't given any specificity of that in their current guidance. Now, hopefully each of you has sort of an understanding of what the basis of the regulations were and have some understanding of what is deemed retaliatory and what's not deemed retaliatory. And then this concept of reasonable possibility. So it's like a two-tiered approach in a sense, right? Reasonable possibility of in a post-accident situation. How you start to think about this in that layering effect, and it's going to help you understand how you can apply this in your workplace. But what are the exemptions? These are, in our opinion, the good news, right? So if you have a DOT-covered employee and under your specific modality, FRA, Federal Motor Carrier Safety Administration, if it requires a drug test, it trumps this rule. Needs specific, right? So each one of you who has DOT-covered employees should annually be looking at your policy and make sure that your DOT policy is in place and that it's any changes in the DOT regulations. And so there's no impact, OSHA no impact on that. If you have a drug-free workplace policy and that policy does not have a blanket accident incident wording, then and this is just for OSHA-covered employees, so that's okay. If following one of the state workers' compensation laws that provide incentives for, like a workers' compensation premium discount law, compensation denial law, and an unemployment denial, all of those are also okay. Again, when we started this, we said, holy cow, there was this uproar that, oh my gosh, we can no longer do post-accident drug testing. Not true. All these voluntary and mandatory laws are acceptable requirements that you are supposed to follow. Those are acceptable, and so it's allowed to be tested. Which is important, right? What's important is, I keep saying this, it's the underlying policy, because you've got to be clear under whose authority you authority is the post-accident test occurring, and that's important, and you have your policy sorted out. The other thing is if you're following an insurance company's incentive. So you may have some incentive by your insurance company. It could be a health care insurance company. It could be one of the other carriers' policies that is incentivizing you for post-accident and incident testing procedures. That's also allowable. That idea that OSHA sort of just said, no, blanket, you cannot test, is wrong. Here's several problems, right? But here's a significant problem. In the preamble where OSHA discussed that drug testing procedures cannot be viewed as discriminatory or retaliatory. This is a quote. They said, drug testing methodology should accurately identify that the employee was impaired at the time of the incident or accident, as opposed to simply having evidence of a drug in the employee's system. This is problematic. So, add a single method. And method for drug testing, I mean urine testing, oral fluid testing, blood testing, some is called oral fluid saliva testing, hair testing. Methods they relate to impairment. So I'm going to do a little tiny bit of an offshoot here. What about medical marijuana? Because that's another thing that's just so prevalent in the workplace. And you're thinking about drugged driving. Law enforcement ability to do a roadside test. It's a simple test. It's not a blood test, right? It's a breath alcohol test. And that breath alcohol test is both a screening and a confirmation. It gives you a level, and the level determines that the person was impaired. And that's because of how your body metabolizes alcohol out of your system. Drug testing is not to do that. Because of how the testing technology currently exists, and because of how it metabolizes drugs out of your system, there is no way to say that a positive drug test equaled to give us some further information. So as an industry, many comments have been made back to OSHA and said, here's the problem. And it's not a problem just for OSHA, right? It's a problem across the board for the United States. It is a problem. There's no way to accurately say this person was, quote unquote, impaired, whatever you want to call it, at that minute. So just putting this in a very sort of simple way and layman's terms, we'll use the marijuana example we just talked about. As an employer, you do not know if employees positive for marijuana, right? Positive drug test was a result of that person smoking in parking lot. On a positive drug test was a result of a person smoking a joint for testing and smoked that joint 2 months ago. That's where this impairment piece gets very, very tricky. So that the agency is going to have to give some more formal guidance. This is also where that third date came into play. A number of employers and employer groups, including the National Association of Manufacturers and Associated Builders and Contractors, so we're talking some pretty big, hefty names, filed suit last week. We probably should have corrected that, but they filed suit a few weeks ago in federal court in Texas, and they're seeking to block parts of the OSHA rule. And so as a result of that, it is believed, they didn't really state that, but as a result of that, delayed their ability to issue those citations and enforce this until November 1st. Personally, and this is strictly Nina French's unofficial opinion, I would not be surprised if it gets further delayed, but we'll have to wait and see. That's going to be one of your action items at the end of this call, is to make sure that you keep abreast of all of these things, because we know there's going to be some additional guidance from the agency, because it has to. They have to. We're still unclear about many of these things, and the issue of impairment is just something that's not determined. And so you can, as an employer, do what they said. You cannot now use a drug test that links specifically to those impairment, because this isn't one. And so there's no way for you to be in compliance with that. So we believe they are going to be providing some more formal guidance on the interpretation of 1904.35. It's either going to probably come in those frequently asked questions, or some sort of compliance directive, or an enforcement memo. So how it's going to come, but we know it's going to have to come. And so it's a sort of a wait and see. I'm going to go back 1 second to this past slide, just again, because this is about drug testing, and this is what TOMO does, drug testing, and it's what they're very good at. So remember that when you are doing drug testing, laboratory-based drug testing is a two-part process, okay? It's a screening drug test, screening test, and then a confirmation test. And when you get those reports back, and the reports show the panel, they show a cutoff level, it's important to understand that what that means as an employer. And what it means is that drug test went in. If you do a 5-panel or a 7-panel or a 10-panel or a 20-panel, every drug in that test is taken into the laboratory, and an initial screening test is done. Screening tests all drugs in the panel at one time. If any drug is at or above the screening level, then this goes on. That same sample, just another bit of it, right? So they call it an aliquot in a urine case. But a portion of that sample goes on to another test. That's a confirmation test. It's a very exacting test. It's different technology. And they're going to test in that second test for whatever screen positive. So if it's marijuana, cocaine, PCP, amphetamines, and opiates in your screening, and the marijuana and cocaine come back positive in screening, they're going to do 2 different confirmation tests, one for light and then one for cocaine. So different tests. And then only if test comes back at or the confirmation testing level, is it reported to the laboratory as a positive drug test result. So significant science, but where impairment comes into play, because those sort of nanograms, what they're detecting in your system could be. I'm going to talk a little bit about how window of detection plays a role in impairment in some of the different drug testing methodologies that are available today, and that's part of what your action item lists are. So I'll go through these. We're at the half hour. Our intention today was to cover about 2 hours, or cover about 45 minutes, and then if we see some questions, we'll roll some of the questions in our last 15 minutes. But action items are pretty important because it gives you something that you can walk away from today's training with and do to make sure that you're in compliance in advance of that November date. No time present, that's going to come up very, very quickly. So first thing is to review your post-accident incident definitions. What does policy say, and under whose authority is your policy acting? Make you don't have blanket policy language that could be deemed to be retaliatory, and that it or discourages report. I again sort of I've been in this industry for a long time now. If that was sort of printed out of somewhere or that has been in a desk drawer, it's time to pull it out. TOMO has partnered with CCG. If you are interested in having your policy reviewed, or if it's time to have a policy rewritten, non-DOT, CCG does those, so reach out. We have some contact information at the end of this. Reach out to TOMO, and they will give you information on how to get in touch with us to do those policies. And they're fast, 7 to 10 days. Because of this gray area with OSHA, if you are OSHA regulated, and I'm assuming of all the attendees, there's hundreds of you on this phone, I'm assuming you're on because you're in compliance issue. It will be compliant based we know today, and then should the agency come out with changes, updates, or clarifications, we would go back and help you update the policies that we create to what the new requirements say, or the new questions say. But it is a relatively quick and easy process. Sharon Boucher is on the phone with us, and she's our compliance manager, and work directly with Sharon or somebody else on the team, but it's generally directly with Sharon, and she can get you turned around in like 7 to 10 business days. So this isn't something that's horribly involved, unless, of course, you are an employer who's in all 50 states, and then it's obviously going to be a bigger process. But it's an important process. And, I'll remind everybody that outside of OSHA, there have been changes, both related to mandatory and voluntary laws in different states. And there have been many updates regarding marijuana, legalized marijuana, either medicinal or recreational. And so it's really important that you're reviewing those policies periodically to make sure that they're up to date, because laws are changing now in terms of drug testing faster than they ever have, in the past. The other thing is that you need to review your post-accident and reporting procedures. So this is outside of policy. This is where you need to look at some of the processes that your employees have to follow to report an injury or accident. And we recommend that you consider a post-accident checklist. So some of you know that there's like FMCSA, the Federal Motor Carrier Safety Administration. So truck drivers, right, CDL drivers. There's the post-accident decision tree that they use. And that's kind of what we're talking about here. So a checklist or a decision tree. And it isn't rocket science. Maybe there's some rocket scientists on this phone, right? It's not rocket science. It's, fatality. Yes, if there was fatality, then the test is required, right? If there was not a fatality, well then, and again, this is FMCSA's rules, right? Well, was the driver cited with a traffic violation? If the answer is yes, then there's an injury that requires the injured person to leave the scene of the accident for immediate medical attention. Yes, well then you test. No, then you do something else. If the driver wasn't cited, then there's no test required. And so it's a decision tree, and then based on that decision tree that you're using as an employer that works in your workplace, then that works for you as an employer in your workplace, right? So each one of these is going to be customized to you. Then you want to have a post-accident checklist that follows your tree. And implementation, what you've done. And so the next bullet talks about make drafting a component of the overall accident investigation. So again, we're recommending that you use the decision tree and that you use it as a means and for consistently documenting what is accident investigation, and that the investigation before you do it, right? So you want to have, if an accident comes and an employee reports it, or it's, it just is in the workplace, you want your managers and your supervisors to have paperwork, you want to follow it, you want to document, you want to have a decision tree that is consistent, and you want to until you've done post-accident investigation. And only after the post-accident investigation then that a post-accident drug test is required, do you do a drug test? So again, you're going to investigation, the person's got to go, they have to have medical attention. That still is an incident or an accident. We're going to go through this checklist, but it's going to be a simple decision that says, no, we're not going to require a drug test in this case. If it's a reportable OSHA accident, reportable OSHA incident, I'm going to carpal tunnels again, because really the only one I know. I'm going to do the same thing, a post-accident injury checklist, but I'm going to require a drug test. It's if it falls under the OSHA requirements of an injury or an accident, but it is not going to require a drug test in those cases. So use that and use it as a way to consistently document the process that you're using. Create the parameters that are based on sort of been true. T requires that you do a post-accident drug test in 8 to 32 hours after then you're required to do the post-accident drug test. Not in your policy. Use it in your procedures, because then you can fall back on OSHA. And to some degree right now, what you want to do is say, we did the best we could in following your rules, given where the rules were and given the specificity you provided in the rules. And we DOT requirements and definitions of post-accident, so that it was what something nationally accepted and industry accepted. TOMO provides reasonable suspicion training. So reasonable suspicion training required for DOT employees. That reasonable suspicion training is very similar to this idea of possibility. And so if your employer, or if your managers and your supervisors have been trained in drug testing and have been trained on how to use your checklist and trained on how to use sort of the decision tree that you put in place that follows your policy, then you really put yourself a low risk. You can say that we have done our best in the documenting of our reasonable suspicion findings. We've done the best in our development of our policies and our procedures, and we've invested in training so that we could follow those regulations were and that we were non-discriminatory. And again, the documentation training for reasonable suspicion does talk about, identifying erratic or unusual behavior that could be contributing factor in an accident and could be determined to be a sign of drug use. You want to review your state laws, and I'm not going to go into too much depth about these, but I'm hoping most of you know this. Many states, I think there are 15 states, and Sharon, if you're unmuted, you're welcome to jump in on that, but have different policy language requirements for what a drug-free workplace would be, but many of them have specific requirements. And again, if you're following those mandatory testing laws, then that is okay, and that won't be a citation under OSHA. If you're going to a drug-free workplace or a state workers' compensation law, that's a change, and OSHA cannot find a violation when the post-accident drug test is performed in compliance with those laws. not taking advantage of those, you really should look into them. So Missouri, and we picked that because that's where TOMO is located, and so many of you were thinking as well. There's no mandatory drug testing laws, but there are voluntary unemployment denial law and voluntary workers' compensation denial law that allow you. I mean, it's people still question what it is, but it's very simply, in voluntary workers' compensation denial law, is that based on if you're following those requirements, then you can deny a claim. A state has a voluntary workers' compensation premium law, which Missouri doesn't, but some operating in multiple states, that allows you to take a percentage discount off of your policy if you're those. So that can be significant. If it's I think they go from 5% to about 7.5%, depending on the state. So if you have a $100 workers' comp premium, think of the significant savings that can be for you. So it's important to know they are, and it's not going to have an effect. So know what your state drug testing laws are and take examples of them. We do at Current Consulting actually have statedrugtestinglaws.com, which we're relaunching in the fall, and it's a membership site. We do give discounts to TOMO clients that allows you access to both mandated and laws in all 50 states, and then for those states that have neither, has information on significant case law in those states. And we'll be relaunching that in the fall, so that if you're a single state employer, it becomes sort of an option for you. So if that's something that you think you can use after you've updated your policy for ongoing questions, there are resources available for you to know that. But it's just critical for you to know the state laws that affect you as an employer and to take advantage of those. Consider implementing a random drug testing program. Now where we're getting a little bit more into best practice and not specifically related to OSHA, but think about it as an employer. Many states allow random drug testing, and the OSHA regulations don't apply to that, because this is or post-accident or reasonable suspicion. So if you are considering the impact and the cost of safety in your workplace, then think about implementing a percentage of your population. This isn't your DOT, it's separate, right? A small percentage can be a significant deterrent. You know as an employee that there is a possibility that you can walk in that door tomorrow and be drug tested. It may you from arriving at the workplace injured, and it may save you as an employer that investment in the random drug testing. It may save you all of those worker compensation claims and those, softer indirect costs that result from drug use in the workplace, right? So absenteeism, lack of productivity, lower morale. There's a long list of the sort of drug use in the workplace, and it's important for you to know those. And random drug testing can help deter it. TOMO can administer your random drug testing program. They can do the selection, the notation, the testing. They can come in and do the on-site collection services if you want to do it that way. And it's an easy way for you to administer the program, and the cost of the program, you analyze it, is often offset by the savings in the workers' comp claims and the absenteeism and those things that cost you as an employer. And then consider also putting a last chance agreement in after a post-accident test, so that if the employee's dismissed, they can't say, no, this was retaliatory. You say, no. We had a last chance agreement with that employee. I think this may be our last one, maybe not. Consider laboratory-based oral fluid testing. So some of you say we don't do that. We do urine testing, and urine testing is tried and true, and it's great. Laboratory-based oral fluid testing has been around for years. The reason reason we say this, and we say this as it applies to the OSHA regulations, is that problem, right? Go back to yield sign, problem on that slide. We said there's a problem, and it's you to link it to the drug test chairman. Problem, urine does detect for window of detection for urine is longer than fluid. So it does two things, right? Immediate use may not be picked up. So if I walked out the door, I smoked a joint, I came back in, I tripped and fell, or I drove that forklift and it caused an accident, it may not be picked up in urine. It's immediate. It's all fluid and blood. The wind detection, that's immediate, right? On the tail end, oral drug testing does not show the window of detection for the drugs in that panel is not as long. So it kind of ties up for you the idea that I smoked last Wednesday and it's still in my system, because oral fluid drug testing, the window's not that long. Now, if any of you are doing it, one of the things that sounds counterintuitive is the positivity rate for oral fluid drug testing is generally about the same as in urine drug testing, so you're not going to miss positives. That's why I think there's a misinterpretation that you would miss positives. You don't. You get recent use, and because you administer it right there, you can have, because you're administering it on the spot, then you because you're administering the oral fluid drug testing on the spot, you're not allowing those people to have like 2 days or 3 days to try and adulterate their urine specimen. And so, again, you can do those collections through TOMO. They can collect oral fluid specimens, and it's an idea to think about to get a little bit closer to that idea. But then be super careful, because even though it's allowed in almost all states, it's allowed in some of the voluntary or mandatory programs, in a couple of them, and not allowed for DOT testing yet. It's on, but it's not allowed yet. And then finally, you keep in touch with this. This isn't a once and done. You have to keep your eye on the lawsuit. We'll see what's going to come out, the adjustments or the clarifications that they're going to make, and you have to be kept updated on that. And that's going to be really important, because it is going to change. It's not a once and done. So again, we're just going to recap the key points. That is now delayed. It was originally effective, and when we say the citations or the policy stuff was originally 10th, there's now that reprieve to November 1st, that you're to be non-retaliatory, that you can't have a blanket policy statement, and that it does not impact DOT employees, mandatory state laws, voluntary state laws, or drug-free workplace program, and that we should really strongly encourage reasonable suspicion training and a review of those policy statements so that you're in compliance in advance of the OSHA regulations. With that, I'm going to pause. I'll ask you to see if we have any questions, and if we don't, everybody gets a few free minutes in their day.
Thank you, Nina. That was information. We do have a few questions. I think that was maybe still a little bit unsure of if you have in your policy where it states that all worker comp injuries or illnesses will be listed, if it would still be considered a retaliation claim.
Yeah, I'm not sure I'm super comfortable making a statement without reading the wording of the policy, and I would want somebody like Sharon Botcher or Andrew Current to review that on our team. But if it is, again, in compliance with a workers' compensation premium discount, a voluntary law, then likely no. But if it could be deemed blanket, could be. And so it again is sort of that decision tree. And Sharon, if you're unmuted, you can certainly
don't think we have Sharon unmuted.
We can ask Sharon to follow up when we send out the recording on that a little bit, but I think it goes to you have to have your policy reviewed specifically to check the language and make sure that it's not a blanket statement. I hope that's a decent answer.
Sure. And of course, you who are on the call with us, just a really quick reminder that this presentation is being recorded, and you will receive information after the presentation on how to access the and the slides. So I've unmuted the lines of the panelists that I've had access to the lines of from our representatives of TOMO with us on the line as well. And so if any of you want to step in for any of these questions, of course, Nina, you can field them over. One question that we had asks, should reasonable possibility now be important wording included in a company's DNA testing policy?
Reasonable possibility is important wording in the training. I think reasonable possibility is important work in your procedures. TBD as to whether or not reasonable possibility is going to be firm enough language in a policy statement as it relates to what the procedure would be. I do think the idea of reasonable possibility is going to be significant for OSHA-covered employers and how they train people to differentiate between an accident that or incident that requires drug testing and one that doesn't.
Okay. Looking at the policies, and this is kind of, you touched on this a little bit before, and obviously this is kind of Sharon Andrews' area through CCG, then would it be advisable to change your policy from saying blanket to reasonable suspicion post-accident testing, or would that not really sidestep the whole mess that is with OSHA right now, unless state laws are in place to support that?
Important to what type of testing you're doing, if it is a post-accident or post-incident test under OSHA authority. And that's when this idea of reasonable possibility comes in, the decision tree comes in to determine, and the documentation comes into play. That's where it's going to be really important as part of the policy and how you administer your policy. I also think it's very important to continue to clarify the difference between a post-accident drug test, a post-incident drug test, and you can call those the same things, right? But a reasonable suspicion drug test, because a reasonable suspicion drug test is complete. Because OSHA is talking about that. OSHA is talking just about specifically post-accident testing, and then it's like that second level of criteria that it has to have reasonable possibility. They're moving into those other types of tests because they say in your pre-employment drug test or your reasonable suspicion test under your company policy. So it's important to, again, review the policy, be clear, and that reasonable possibility is like a second, as OSHA is second accident testing.
Okay. That's
Verizon Wireless. The wireless customer you called is not available at this time. Please try again later. Announcement 1659-2.
One of our panelists is Jessica. I'll do a quick wrap up because we have some good interference now.
At this time. Please call again later. Announcement 1.
So we're going to close out today's session. Thank you, everyone, for coming. If you're a panelist and you're on a phone and you can disconnect that would be great. But the last slide gives you information on how to reach team at TOMO if you have any questions about your policy, about their collection services, about their testing services, or about any of your employer supervising training needs. Please reach out to the team at TOMO, and they are ready to take your call and support you in that. And very much, TOMO, for inviting us to come and speak to your group. Nice day, everyone. Thank you.
Thank you. On behalf of TOMO Drug Testing, we hope that you found today's presentation informative and helpful. As was mentioned previously, you will receive information how to access the recording of this presentation. And if you submit a question that was not answered, those questions will be sent over to the TOMO and Current Consulting Group, and we will make sure that the right person gets in touch with you with the right answers as soon as possible. Thank you very much for your attendance today. This concludes today's webinar.